Hi, welcome to HOA Hell. I'm your host, Michael Kushner, and with me today, as usual, is Senior Associate at MBK Chapman, Sam Kill.
Hello, Mike. Good to be with you.
Good, Sam. I'm glad to have you here today.
Thank you.
I think your participation will be very helpful today. This issue is of supreme importance for anybody in the state of California that lives in a condominium that is governed by an HOA, which is most of the condomos are governed by HOAs, okay? If you live in a condominium or you live in a townhome that is considered a condominium in the public record, we're under the plat map, okay? Then you need to listen to this episode because this could save you hundreds of thousands of dollars. At least between $100,000 and $200,000 in attorney's fees, and possibly much more than that in damages.
Especially in Southern California.
Especially in Southern California, but all over the state because we have fires everywhere.
Right.
What we're talking about today is a very little known, at least to lay people and homeowners, disclosure that is required of all homeowners in the state of California who are selling their house or condo or townhome that happens to be located in a high fire zone, okay? And those zones are public record. You can Google, do I live in a high fire zone? And you'll be able to find out if you do. Because there are statutory disclosures that must be made. And there are, for the most part, if your agent is using a CAR form, the California Association of Realtors form, they have the pre-printed disclosures. The problem is that the legislature made a slight mistake when they drafted this, and they didn't differentiate or they didn't recognize that condominium owners are in a very unique position. So they are unable, in many cases, to be able to make these disclosures because they neither own that part of the property, okay, or they don't control it. They aren't allowed to go up and look and see what is there and what's not,
right,
because they aren't in charge of ever putting it in or paying for it. And yet you're still required under the statute to comply. So that's what we're talking about today. If you are a single family home owner, you can probably skip this episode because this really just applies to condo owners or townhome owners where your townhome is considered a condo. It's not a PD, okay? And this is, given the importance, this is a surprisingly obscure statute. But it is in full force and effect. It is required. And for reasons we're going to discuss later, if you fail to make a disclosure or you make an improper disclosure, then the buyer can go after you for failure to disclose. They can unwind the sale. They can get back their money. You're going to be responsible for their attorney's fees. It's a big mess, and it's unfair. And it would take a very simple fix by the legislature just to fix it. And they haven't done it yet. They probably will at some point, but that hasn't happened yet. So if you are an owner in one of these residential properties and you're in a high fire hazard zone, then these disclosures are mandatory, and you've got to know the things that I'm going to tell you in this podcast. So pay close attention, okay? Now, here's the problem. If you are, and your agent hopefully will hand you, among all the, if you've ever sold a home, you'll know that you get a list of documents you need to sign. There's lots of disclosures, okay? Your agent should be printing these out for you, especially if they're using CAR forms, which most do, okay? But most condo owners that look through this stuff will assume, rationally and logically will assume, that this doesn't apply to them, okay? For example, I don't own the roof. I'm not the owner of the roof, so I don't have to maintain, and I don't maintain the landscaping. So this isn't me, okay? But that's not how the statute's written. It talks about the property owner, and when you're selling your condo, you're considered the property owner, even though you don't own the roof or the landscaping surrounding your building. It's not you, it's the HOA. Statute applies to you. That's the problem, and that's what we're going to talk about today. I'm going to teach you how to comply with the statute until they get around to changing it and fixing the problem. Because the alternative to doing that is disaster for you.
Indeed.
Okay.
Absolutely.
Now, if you are a condo owner and you don't live in a high fire zone, this doesn't matter to you. Okay? So what the law says and who it applies to. Let's start with that. Sam, talk to me about this statute
Okay.
and teach our
Sure.
teach our listeners what the statute says.
I'll keep it simple and straightforward. Under Civil Code 1102.19,
Okay.
any seller of a residential dwelling in a condo setting,
Or in a single family home.
or a single family,
Anything.
technically too, our emphasis is the condo here, has a mandatory disclosure requirement pertaining to their property being in a designated fire zone, right,
Okay.
or high hazard zone.
And they can get that on the internet.
Correct. That's number one. Number two is disclosures about the condition and status of vegetation and landscaping surrounding the property.
Okay, so let's break this down. You have a statute that says if you live in a high fire zone, whether you're in a condo, a townhome, or a single family dwelling, you have to make certain disclosures if you happen to be one of those people that lives in this high fire zone.
Correct.
And you'll get those on the internet. And then the statute requires specific disclosures that must be made.
Right.
Let's walk through the three main ones. Walk me through. What's the first one?
Well, the first one is that your property, the subject property that's subject to the sale, is in fact in a designated fire zone.
Okay, so you have to say,
Right.
I'm one of them.
Right.
Okay,
One.
that's
Two,
easy.
Two is the condition and status of vegetation and landscaping around the property.
Okay, so that probably has to do with whether or not you've got the mandatory defensible zone,
Correct.
stuff like that.
Any buffer
Okay.
zones, etc.
Right, exactly. Okay, what's the third one?
And the third one is if you have any fire hardened features.
Fire hardened features. What does that mean?
Well, that means, in short, any anti-combustible hardened features, such as, let's say, roofs that are more protected from, let's say, combusting, or let's say double and triple paint windows with tempered glass.
So if I have a wood shingle roof, those things go up like tinder.
They do.
I have to disclose I have a wood shingle roof.
Right.
If I have a roof made of tile, Spanish tile or clay or asphalt, then I would say I have a fire-resistant roof made
Correct.
of tile or whatever it is.
So 11.2.19 under the Civil Code.
1102.19.
1102.19
Okay.
specifically wants express disclosures as to fire hardened and protected features.
Okay.
So if you're representing, or you're supposed to represent, that these features are extra protected or extra resistant to fire or combustion.
Okay.
So, and obviously, I would imagine that would also enhance the marketability of the property.
I
in
agree.
those zones. Yeah.
I know that it talks about at one point if you have triple or double pane windows,
Right. The tempered glass. Yeah.
which are provide fire hardening features, right?
Exactly.
And then if you've ever watched any of the shows that have fires, they talk about sometimes like the embers from a fire will go into the little holes at the top of people's roofs into their attic.
Right.
And that's where it lights stuff up. Because people have stucco often, and that's not easily combustible, but that's not where the fire starts.
That's exactly right. And that's another one, I think.
It gets sucked in, right?
Right. If you have covered eaves or,
Right.
or protectant elements.
So there are these things you can buy from these companies
Right.
that cover what those vents that just used to be open vents. They cover them so that so when embers get knocked into them, they don't get sucked in.
And maybe gutters too. I mean,
Right.
I mean, all those features.
So if you have that, you want to say it. So
Absolutely.
do you have a fire hardened roof? Do you have a fire hardened? Maybe even if you've got fire hardened elements, on the side of the house. Like let's say your stucco is treated with
100%. Yes.
Right. Okay. So you have to disclose all that. If you have ignition resistant walls, if you have decking and fencing,
Right.
is it fire hardened? Is it made of non-combustible material?
Right.
Like I suppose metal.
Or perhaps treat it with something that
Or
makes
treated,
it,
right? The pressure treated wood
Yeah.
or whatever. Okay.
Yeah.
So you got three disclosures then. You got to disclose I live in a high fire zone or I don't. 2, I have these fire hardened features, and 3, describe the vegetation and then discuss what steps have been taken, if any.
100%.
Okay.
Yeah.
So that's 1102.19. Okay. And the surprise is, if I'm selling my house, I live in a single family home, then it's all on me. I'm the one that would have installed.
You have control. Yeah, you have control over all those features.
I'm the one that hires the landscaper or does it myself, maintains my zone. I'm the one that calls in that company that puts in those things that block the embers from coming in. So I would disclose all that, right? Because I have to. But you live in a condo, and that's off the table.
Right.
You're not allowed to get up there. First of all, how would you know? Because you didn't buy it, unless you're paying attention to every single spending from the board, and that's a full-time job.
Right.
So you have to inquire.
You really
And that's the problem.
at the mercy of the association.
That's right. And that's the problem. you can't, on your own, comply with this statute as a condo owner or a townhome that is considered a condo. So from now on, I'm just going to call them one. You can't comply without the cooperation of somebody else. You're not on your own. And the problem is that they don't give it to you. Or you're relying on them to give you the truth.
Right.
Again, are they liable? No.
No.
They didn't sign your contract. It's between you and the buyer of your property. You're in escrow with whoever. Escrow closes. You're the seller. They're the buyer. You guys are in privity. Your HOA is not a party. Doesn't mean you can't bring them in on an indemnity claim or negligence. But I'm just saying, this is all on you folks.
Right.
Okay? So, for obvious reasons, I think it's obvious, this doesn't make any sense. The statute certainly wasn't intended. The statute's a good idea. We don't like caveat emptor, buyer beware. We like, if you're aware of something that's wrong, disclose it. And this is along those same lines. I have no issue with this. The only issue I have is that the legislature didn't think it through when it came to condos.
Yeah.
And who's in charge and who owns. Okay? And so condo owners have no idea that this applies to them, because if just based on pure unadulterated logic, it wouldn't apply to them. It would be the HOA's duty. But it's not, because the statute wasn't written that way. Okay? And it was an oversight, but that's not going to help you. Okay? So it's frustrating, to say the least, because the statute says seller, but it doesn't carve out that exception for common interest developments, specifically condos as common interest developments. Okay? So you're on the hook. Now, the California Association of Realtors, the one that's produced that form, and the organization whose contracts probably make up the bulk of all residential sales in the state of California, okay, they're aware of this from the beginning. They brought this up to the attention. They flagged this early on. They might have even flagged it during committee before a law went into effect. That I don't know. But I know they were on top of this. And they have not yet been able to get the legislature to modify or amend this statute. They recognize the issue immediately. If they recognize the issue immediately, it's because it really is an issue. Yeah. I'm not just whistling Dixie here, okay? It's an issue, and it's an issue that the very organization whose forms most people use flagged this at the beginning. It just hasn't gotten anywhere. The problem is a lot doesn't necessarily trickle down to brokers and agents. So you might ask your agent, am I in danger here? Never trust your agent on that. This is between you and the buyer. Get on the internet, find out if your house is in this zone. If it's not, you're good. You don't have the disclosures, not you. But if you are, if you're like tens of thousands of people that live in a high fire zone, then this is on you, and you don't trust your agent to tell you whether or not you're legally compliant. Your agent's not a lawyer, okay? Your broker's not a lawyer. So they're not qualified to interpret a contract for you. You're going to need a lawyer to tell you if you're in compliance. But if you follow the tips in this podcast, you'll go a long way toward making sure you're protecting yourself, because I've thought these issues through.
Right.
Okay? Now, for those of you who know, and you know, this podcast is not legal advice. I established no legal relationship with any listener. Okay? But it doesn't mean that I can't give you the benefit of my 30 years of experience. Take it or leave it, that's up to you.
Yeah.
Okay? So how does this mismatch put you, regular people in a high fire zone that live in a condo, at real risk? How does that happen? Well, there's two primary ways that this affects your life. Okay? Two primary ways that this can cost you real money and real liability. Okay? Way number one.
Well, there could be transactional fallout. Well, what that basically means is in the midst of a transaction for the sale of the property, you may have issues running into disclosure-related issues with the buyer, with the lender, or the title company.
Well, let's say you get this form and you don't understand it because you're like, this clearly doesn't apply to me. I don't own the roof and I don't own the vegetation, so you leave it blank.
Right.
And then what happens when it goes through
if the form is
underwriting?
If the form is deemed incomplete or missing information, of course, then guess what? It gets red flagged. It could be on.
You lose the sale.
It could be by the buyer, could be by the lender, could be by the title company, others perhaps in the process, and you could lose a sale. It might delay escrow closing. Or create other hurdles to that process. And
let's talk about that. Escrow closing delays can also chase away otherwise, good potential buyers, because let's say they lose a favorable interest rate.
Right.
Because the interest rate was, being locked in for a certain period of time.
Yeah.
Escrow gets extended beyond, because they're not going to close this. If their agent's telling them you can't close this without disclosure here, and you haven't made that disclosure because you don't understand that you're actually supposed to do it and what to do. And again, don't just listen to your broker. Oh yeah, just fill it in and say it's okay. Don't do that, because if you misstate something,
Right.
you're liable, not your broker and your agent, you. And so you could lose a sale just because of this delay, and the person loses favorable interest and says, I'm pulling out.
Right.
Okay.
Yeah.
So transactional fallout's very real, but that's not even the one that worries me the most. It's the second one that worries me more, and that is post-sale liability for failure to disclose.
Yeah.
Or even worse, fraudulent, being sued for fraud. Okay. An intentional tort. The accusation being that you knew this stuff and then either misrepresented facts or failed to disclose it all. Okay. If you fail to disclose a required fact, then you've got liability there. If you improperly disclose a required fact, then you've got potential fraud liability there.
Right.
And the law doesn't care currently, as it's written today, that you have no control or rights to maintain, even get on and inspect the roof. You're not allowed as an owner to get a ladder, go up the side of your building, get on the roof and look at the shingles to see if they're fire resistant. Yeah. Even if you hired a roofer, tell me what this is so I can make a disclosure. Remember, that was one of the things you talked about, a fire hardened amenity, right?
Right.
You're not even allowed to do that because it's common area, and you're not, and it's common area that homeowners aren't allowed to access without board approval. You are not allowed to get a ladder and get on top of your condo roof without the HOA's permission.
Call to a hearing if you do that. Yeah.
Yeah, you'll get in trouble. You can't do it, so you can't comply. That's a very, very big deal. So, but if you leave it blank, you're not in compliance. If you lie or make something up, you're taking a big risk. You better be right, okay?
Yeah.
In an ideal situation, the law would be written correctly to put the onus on the HOA to provide you. So maybe the law would say, once a homeowner submits a written, on a car form, submits a disclosure from the broker that the house is an escrow, the HOA has X amount of days to provide the required disclosures under 1102.19, right? That's the way it should be written. But let's say it's not. It'd be nice, sure be nice if the Davis-Sterling Act said, okay, in cases involving that statute, the HOA needs to cooperate within X amount of days of being notified of a potential sale or escrow being opened.
Yeah.
That would be very nice too. Neither of those exist. So what responsible people whose brokers or agents were aware of this have gone and done is they've submitted a little package to the HOA and said, hey, we need to be able to answer these 3 questions. I've already answered question 1. I looked on the internet. I'm in a high fire zone. So can you tell me what fire hardened features we have in terms of eaves and roof and all that? Can you tell me that for my building? And can you also tell me about the landscaping, surrounding landscaping? And then HOAs have done one of 2 things. Some HOAs immediately cooperate. And then in the disclosure, you're very careful to say, I don't have control over these elements. However, I submitted a request and here's what I got from my HOA. And then boom, you put it in. And then they can't accuse you of intentional misrepresentation because it's obvious that it wasn't your representation. But a lot of HOAs just don't respond. Or they say it's not our responsibility. Or we'll get to it at the next meeting, but the next meeting's 30 days.
Yeah.
Okay, you can't. Escrow is usually 30, 60 days. So, and typically, the buyers waive the disclosures after 17 days, unless it says otherwise, right? I mean, that's the auto default in the car form. So, that doesn't work. That's a problem, and it happens every day to lots and lots of people, and they're between a rock and a hard place here. Okay, that's the issue. So. Never guess on these disclosures and never leave it blank, but you got to tell the truth. And that's the overarching rule here. Tell the truth. So we just talked for a little bit about what the law ought to say. Let's hope that it happens. I think it will, because I don't think it's controversial.
Agreed.
Okay?
Yeah.
But here's what, given the current situation, here's what brokers and escrow agents and real estate agents are getting wrong every day. I know for a fact, because this came to our attention from a couple of different clients, that their agent or broker, usually an agent, has actually advising them or advised them during this process, and they were uncomfortable with it. So why they came to us.
Right.
And they didn't come to us too late. We were able to help them during the sale. So we were able to jump in. And both these cases, it didn't sound right, and so they just came to us for a consult. Their agents were telling them that the disclosures weren't required because they didn't own the roof. And therefore, in other words, these agents were trying to interpret a statute as if they were lawyers, and they're not qualified. Okay? And the information was just wrong.
Yeah.
Dead wrong. In both cases, their agent said the same thing. Whoever class these agents are going to learn this stuff, they're getting the wrong lesson.
I had one consultation where the agent apparently told this potential client of ours, unless you're in a dispute posture with your association, you don't need to disclose, which is completely asinine. Makes no sense.
That makes zero sense. It's not even logical.
No.
At least it's logical to assume that it must not apply to me because I don't have any control or ownership.
Yeah.
No.
Yeah.
That's not true. That's not even rational. The information that these agents, not all agents, there's a lot of agents that know this stuff, but there's also a lot that don't. And it's hard to tell who's who if you don't know, okay? These agents are giving these people wrong information. We got 2 of these within like 6-week period. So it can't be a coincidence. It was after the Palisades fire. I think that maybe sparked some of these, okay? Yeah. Now, the California Association of Realtors, which most agents in California subscribe to and use, okay, which is why those forms are so ubiquitous, they actually issued a bulletin to their members. Agents and brokers are the members, right? Clarifying the law. Why do you think they did that? Because they learned that it was virtually an epidemic of wrong information. But that presupposes that these agents are actually reading these bulletins.
Yeah.
I don't know if they are, guys. I'm not going to rely. If I'm you, I'm not relying on whether my agent is keeping up to date with the news that he or she is supposed to keep up to date with. Right. The bottom line is the California Association of Realtors people actually issued an update because this was so abused, and they were hearing it also. And they were probably getting questions from their own members. This is what I've been telling people. Am I wrong? And like, yeah, you're wrong. And you are creating massive liability for your clients and possibly for you too, because a homeowner is going to probably suck them in under indemnity if that's what they were told, but it's not in writing. Good luck proving the agent ever told you that.
Right.
So it's a big problem. Many agents are working off of just wrong information, or they feel that they're qualified to render an opinion about a statute when you don't even have to have a college degree to be an agent. You just come out of high school, take your test, and be done. I mean, it's insane that they feel like they can look at a statute and interpret it. Okay? Because if the buyer later discovers that property was in a fire zone and it wasn't disclosed, you omitted that, okay? You just didn't do it. You could be in big trouble. You're definitely going to be in the crosshairs, okay? Yeah. Now, there is arguments that a good lawyer can make as to, if the disclosure was left blank, that's something their agent should have pointed out. They shouldn't have closed without the disclosure, blah, blah, blah. There's arguments we can make, but the statute does require the affirmative disclosure, and so you're still in violation. So you're in crosshairs at the very least. Don't put yourself there, okay? So why does this matter? On a legal basis or a financial basis, why does this matter? Well, I think we've talked about it. The potential liabilities in terms of financial liability for the torts that you can be accused of, failure to disclose, fraud, whatever it is,
huge,
negligence, are real and very expensive, okay? And your insurance isn't covering that, folks. Insurance isn't covering that. This is going to come out of your pocket. The more buyers out there that don't do these right, the more liability, the bigger the problem is going to be. We are having lots of fires, and you have lots of properties being destroyed. And I've never looked to see whether the Palisades, for example, or Altadena, if those were high fire zones. I didn't look it up because I don't live there. But if they were, I guarantee you, now's the time when recent buyers are going to be looking at their contracts. So I have a feeling we're going to have business pick up. It will. We will get people hiring us to prosecute or defend, because if there's a disclose, if it turns out that any of those homes in the last year's big, massive, devastating fires in Palisades and Altadena, if those turned out to be in high fire zone or any portion of, I promise you, we're going to see upticks in business on that because people are going to start looking. Yeah. I just bought this 6 months ago. I wonder if I got look at that. That's why this matters, folks. This matters. So let's get to how do we solve this while the legislature is not fixing things yet. What do we do to protect ourselves from this happening to us? I'm about to sell my condo, or I'm about to buy a condo. How do I protect? Well, one, today, get on the internet and confirm whether or not your property is located in a high fire zone.
Right.
If the answer's no, then you are safe. Now, these designations can change over time, right?
They can, yeah.
I would look every couple of years, just done. Okay, go to Google, type in, how do I find out if I'm in a high fire zone designation area? It'll send you to the website. I think it's probably a .gov. Okay.
Yeah.
I forgot to look.
I haven't checked.
Yeah. But I did Google it and I saw a lot of places to tell you. So
okay.
I just didn't look at if one of them was a .gov. But it'd be nice if it was a .gov. I think it's going to be. So you want that one. Okay. Be careful. Don't click on one where they're trying to sell you a bunch of fire hardening features. You're going to start getting that. That's the wrong one. The government's never going to try to sell you something. Okay. So confirm whether or not you're there. If you aren't, it's irrelevant to you, at least for now. If you are, okay, you go to step 2. Okay. Step 2. Before you even do anything regarding getting your house on the market or selling, send out a notice to your HOA or request to the management company or the HOA an email. Please tell me whether what materials are currently on the exterior of my building. So, if there's like 20 buildings in your community, say, hey, I live in unit blank blank. So in my building, what building materials were used on the exterior? Okay, they should be able to tell you this kind of stucco, this kind of this, and then you can look up to see whether those are fire hardened. That's it, easy peasy. Okay, what can I please get a copy of the landscaping maintenance records?
Right.
Can I have that? I would like a copy of the landscaping maintenance records. And could you tell me while you're at it whether or not the board has taken any specific action to create safe zones or fire block? Remember, if you remember the last episode, or recently we completed an episode where we talked about my HOA, where I went and asked my HOA, why would he spend 40 grand?
Right.
Why did we spend 40,000? It turns out the fire marshal had come and taken a look at the overgrowth on some of our slopes and said those have to be trimmed. The reason the fire marshal said that is to create this buffer. That is the information that we're talking about here. So if your HOA, if I was the one, if I was in a condo and it was my HOA had condos, I might ask, what steps has the HOA taken to create buffers? And they could say, well, we just spent $40,000 having all the trees trimmed to create based on the fire marshal's recommendation or order. It wasn't a recommendation, it was an order to cut the trees up to the 600 foot or 300 foot limit. That's what you want from the HOA. And you want this before you even sell, before you get into escrow, okay? The one you talked about, ask, can I have, what fire hardening features have we implemented on our roof, our eaves, our what do you call it, vents, and any on any decks or porches? Because remember, a lot of decks, a lot of balconies and decks they're exclusive use, but they're still common area, and the maintenance responsibilities typically fall with the HOA. So what are those made of? What fire hardening features do we have on all of these different things? And whether or not the association has I guess this is tied to the landscaping, but whether or not we've done anything to create any defensible space.
Right.
Those are the things you want information on. Just write those down as you listen to this podcast, or rewind, go back and write those down, and then request those and have them in your file. Okay? That's how you protect yourself. That's the big one. So, number 1, confirm whether or not you live in such a zone. That's easy. Do that yourself. 2, request information from the HOA in advance. Cover the things I just talked about. 3, disclose what you know and what you don't. Talk to me about that. So now we're presupposing we're in contract.
Right. So obviously you've prepared yourself ideally based on those recommended steps, and
now I get the form from the car.
And now you can confidently and affirmatively represent those things received from the association. To the extent you don't know, you can basically make that disclosure.
Well,
and perhaps,
should I guess?
No, you shouldn't guess, but you should basically
So let me ask, should I leave it blank?
No, you should still put something down, and perhaps we can provide the audience some guidance on that.
Let's do that in a second. I want to go back. I shouldn't leave it blank, right?
No,
don't leave it blank because you're violating statute, okay?
Right.
And I should tell the truth.
100%.
Right. So if the truth is, if the HOA is cooperating, giving me everything,
you represent what the HOA stated.
You say,
right.
Although I don't technically own the roof or the walls, I did ask the HOA for all of these things.
Right.
Here's what they gave me, and I'm attaching them to this disclosure.
That's exactly
That's the truth, and you're not leaving it blank. You're actually answering it. But you're also not saying, I am affirmatively representing this under oath kind of thing.
No,
because
of course not.
You don't have the foundation to do that. You're just passing on what you were told, but you are complying with the statute. Now, let's say the HOA doesn't cooperate. You just made a suggestion.
Yeah, if they fail to cooperate, you make that disclosure. Don't leave it blank. Right.
Never leave it blank.
And we can perhaps provide the audience some verbiage to that effect, and with the disclaimer that you made earlier, perhaps post it in the
Okay. So what I hear you
podcast,
saying is maybe I should. So in the YouTube description, I'm going to create a few lines as a suggestion of something that you might want to say. Now, it's not legal advice. You want to vet it with your own attorney. Okay. But what I'm going to suggest is very much along what I just told you. It would be something along the lines of, I live in a condominium. I do not own the roof. I do not own my eaves. I do not own the landscaping surrounding the building in which my condominium is located. And I don't own the walls, on the exterior walls. I don't have any information about the materials used, whether they're whether they are fire hardening features or not. I don't know, since I don't charge a paying or giving orders to the landscapers, I don't know what sort of defense zones have been created. I've made a request. They have not responded, but that's the best I can give.
Right.
That's all you're doing is telling the truth. You never leave it blank.
Right.
But you should explain why you can't give a definitive disclosure. Now, I think you've gone a long way toward getting out of a failure to disclose cause of action, because to the extent the buyer is concerned, having read that non-definitive disclosure, then it's on the buyer, in my opinion, to then say, well, wait a minute, I can't continue unless. Now, if that happens, you have a new demand to make on your board. And that would be, hey, back whenever, on this date, I asked you for information necessary for me to comply with a statute that absolutely applies to me. You ignored me, or you failed to give me, or whatever is the truth. Now, my buyer is threatening to pull out of escrow. If you don't provide me with this information in the next 2 or 3 days, then if I lose this sale, I'm going to hold you liable for my damages. And that is enforceable in court, my friends.
Right.
You have a lawsuit against your HOA. You put them on notice that they are now actively interfering with a signed contract that you have, and it's because of them that that contract's going to go away. Those are real damages, because now you just lost out on a sale. And if something happens with the market, or you have to negotiate a lower price with the next buyer because markets changed, interest rates changed, those are your damages, folks, and they will be held liable. I would absolutely sue an HOA for ignoring that second email. So you got to set the dominoes up here so that we can help you later.
That's fantastic.
So I'll put something in the legal description based on your recommendation. I'll put a little suggestion as to something you could write in the event that your HOA doesn't cooperate with you, which is why I suggest doing it now before you get into contract, so that you have time to mess around with them, okay? Now, so confirm you're in a zone, request information, disclose what you know, never leave blank, and if what you know is nothing, explain why you know nothing, which is what we just talked about. And the next one is attach all the relevant forms, okay? If you've got if your HOA did cooperate and gave you any information, you're gonna just disclose it all. You're just gonna attach it, okay? I don't own any of this, but I'm liable under the statute, so here's my disclosure. Here's the request I made, and you attach the email. Here's the request I made to the HOA, here's their response, and here are the documents they gave me in that response. I'm now attaching it for your review. God bless you. You've now complied with the statute, and they can rely on what the HOA went after them for, okay? So the next one, keep a record of your request and what the HOA told you. This goes back to something that Sam has said in probably 10 episodes at least. Document everything. Anything should be in writing, and you should keep all your writings. Keep them in a folder or an accordion or a briefcase or a box, and just keep them forever, okay? But you want to keep all this stuff, all right? Because that's going to be very valuable when you can prove that you asked the HOA once or twice and they didn't cooperate. And then you used, some verbiage that may be along the suggestions I'm going to give you in the description about, I've tried to comply, but I don't have that information. I sought it out in due course, and they wouldn't give it to me, and blah, 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 okay? And then if none of that works, or if you're in crosshairs and you know it, or you're about to lose your sale, but you haven't yet, you call us at MBK Chapman. If we get involved and we let your HOA, maybe we send that letter to the HOA that says, my client asked you for these disclosures so that he or she could comply with 1102.19. You ignored, or you failed to comply, or whatever it was. Or you said, it's not our issue. We don't have to. It's your duty. Okay? They are now about to lose the sale. If that happens, you're liable, and we'll be suing you next. And you'll be giving them every dollar of that. Okay? If maybe we do that for you, or maybe you've tried it, they ignored that, and you still have some time to save the sale and you want us to get involved. Whatever the case is. Or it's too late, the sale's gone, and you want to go after the HOA. Or the sale's gone, and they are now saying that you violated the statute, and they're talking to their lawyer about going after you. Any of those scenarios, you come to us at MBK Chapman, and we'll help set your HOA straight. Trust me on that. Okay? For obvious reasons, the law needs to change. It does. It hasn't yet. When it does, we'll update. We'll update you. I'll make sure that my listeners know. But right now, it hasn't changed. And so that onus is still on you as condo owners, even though you are suffering from the deficit that the single-family homeowners don't suffer from. Lack of knowledge, information, or even the ability to have knowledge. Because you don't write the checks. You don't hire the people to install these fire hardening things. You don't have any say on any of it. You're not even allowed to get up on the roof and look to see what you got because you'll get in trouble. That's a problem. Legislature needs to fix it. But until they fix it, you got to do the most you can do to protect yourself, and that's follow the steps I just gave you a few minutes ago. Leaving with that on that note, honesty, never leave it blank, and do your due diligence first. Try to get cooperation. Try to get the HOA to give you the information so that you can comply. But above all else, comply. Regardless of what your agent tells you, regardless of that, you comply because your agent's wrong. Okay? I think this was helpful.
Yeah, I think so.
And if you agree with me that it was helpful, then please, we'd love you to give us a thumbs up. And if you haven't already subscribed to this podcast, please do so. It matters to us a lot. If you'd like to leave a comment, we always like to hear from our listeners. And until next time, have a wonderful day.